Hi, everyone. My name is Rozanne Anderson. I'm Vice President and Chief Compliance Officer at Ontario Systems, and I want to take a few minutes today to discuss the U.S. Supreme Court's recent decision in Facebook versus Dogood. If you are using an autodialer, or believe you have been using an autodialer, or you are sending text messages to consumers, please stay with me as I walk through some important information you should know regarding this decision. Let's say at the outset, unless you have completely disconnected over the last 5 days from the internet or any online communications, you are probably well aware of the decision of the United States Supreme Court in this particular case. It's been a long-awaited decision. It really is the decision that resolves conflict among all the circuits in the United States, the Circuit Courts of Appeal, with regard to the definition of an automatic telephone dialing system. I am pleased to report that on April 1st, 2021, the United States Supreme Court in Facebook versus Dogood decided that in order to qualify as an automatic telephone dialing system under the TCPA, a device must have the capacity to either store a telephone number using a random or sequential number generator or to produce a telephone number using a random or sequential number generator. Unless your dialer has one of those two capacities, it shall not be deemed an ATDS under the Telephone Consumer Protection Act. So what does all this mean for you? It means that if you have been using any type of device or system to communicate with consumers that had the capacity or has the capacity for you to load numbers into it and then it dials them at a certain time, at a certain frequency, that is not going to be deemed an automatic telephone dialing system under the Telephone Consumer Protection Act, and therefore, drum roll, you do not need consent to use that system to contact consumers on their mobile phones or to text consumers on their mobile phones. Consent is not required. Now, that is clearly not the end of the story, because some people even ask the question, well, is my dialer compliant now, or is my dialer not compliant? Well, the analysis never was based on whether your dialer was or was not compliant. It was whether or not you even had a dialer. And according to the Supreme Court's decision, you did not have a dialer as that term is used in the Telephone Consumer Protection Act, and that is the reason you no longer need consent to autodial or text consumers. Now, that effectively renders manual contact systems to place calls or to send texts to be legally unnecessary. Now, that is not necessarily the end of the entire story from a compliance standpoint, but I think suffice it to say someone has to say those words, and I'm saying those words right now. Really, the whole purpose of the manual device, the manual text system, that whole purpose was to skirt the definition of an automatic telephone dialing system so that if you did not have the requisite consent, you could communicate with your consumer or constituent population. So, the question remains, though, is there any reason I still should obtain consent when communicating with consumers by way of their mobile phone? And the answer is a resounding yes. There are two instances where you absolutely need consent to communicate with the consumers or your constituents or your patients for that matter. And that is when you leave a pre-recorded message on their mobile phone or use an artificial voice to contact them on their mobile phone. In both of those instances, prior express consent is absolutely required as a condition of using those contact management systems. Now, can you just generally now abandon all call and text frequency restrictions since you don't have to have consent? How about if we just dispel all our other requirements surrounding cell phone communication and text message communication? That is strongly not recommended. In other words, it is highly recommended that you adhere to all state call and text restrictions. Some states refer to them as communication restrictions. Some states refer to them as contact restrictions. Some cases absolutely spell out limitations with regard to frequency for calls and or texts. But whatever the restriction is, you must still adhere to those state restrictions. That has not been overruled by the Supreme Court's decision in Facebook versus Dogood. Now, if you are, just to be clear, if you are using a system whereby you load a series of numbers to your contact management vendor's platform and they initiate the dialing of those numbers, or they send the text messages to the consumers, patients, constituents, you name it, that doesn't really change the analysis at all. You still do not need express consent from the consumers to use that type of a vendor service, and nor do you need it when it's on premise or hosted. So that also kind of begs the question, then do we need manual clicker agents? Probably not. You probably do not need manual clicker agents to launch manual calls because you don't need prior consent to place the call, regardless of the system you are using, or to place the text, regardless of the system you are using, because of the Supreme Court's decision. Now, again, if you're leaving a pre-recorded message or using an artificial voice, yes, you absolutely need consent under the TCPA, and might I add, under many, many, many state automatic dialing announcing device statutes as well. Now, is there any other exposure, I guess, that you could have other than the state restrictions regarding the use of a dialing type of platform? And I will say that the other exposure would pertain to UDAP, unfair, deceptive, or abusive acts and practices. A UDAP violation is still possible because a consumer may still say that the method and the frequency that you applied to your communications by call or text, using, placing them by in any kind of a dialing platform or not, that the method that you used was deceptive, or it constituted harassment or abuse. And so you are not, no caller, no texter is absolutely immunized by this decision from UDAP claims. Now, some people have asked, in particular those who are third-party debt collectors, how does this decision align with the CFPB's new rules for debt collection under Regulation F? And understand this, they work in parallel with one another. This Supreme Court decision does not, let's say, undermine or nullify the work that the CFPB has done in terms of the promulgation of Regulation F. So let me say it this way. The new rules limiting the number of attempts to communicate using a voicemail remain intact. So messages left on a mobile phone in an attempt to communicate with the consumer must still be limited to 7 attempts in 7 consecutive days. Second, even though text messages are not subject to the 7 attempts in 7-day rule, they fall outside of that calling restriction, if you will, excessive texting can still support a harassment claim under Regulation F. Additionally, Regulation F, I think for those of you who are kind of students of the new regulation, makes clear that if you want to enjoy the protections of a safe harbor when texting consumers, Regulation F outlines some very specific steps you must take when obtaining a mobile number in connection with the collection of a particular debt. So if you want to text when collecting a particular debt, you still need to follow the requirements of Regulation F in order to enjoy the safe harbor. The fact that it is or is not an ATDS under the texting platform is an ATDS under the Telephone Consumer Protection Act is basically irrelevant to the conversation. And the last question that I frequently hear now from clients and our own constituents, I guess, of Ontario systems would be, now, do you think Congress, I mean, we've got Democrats controlling all three branches of the federal government, do you think Congress will quickly pass a law to correct this apparent deficiency in the language of the Telephone Consumer Protection Act, the very language that caused the Supreme Court to say an ATDS doesn't exist unless it has the capacity to generate random or sequential numbers? You generate, store, produce random or sequential numbers. And there are a lot of people, a lot of analysts of congressional action who are saying, yes, Congress is going to act very quickly, place it in some sort of a reconciliation bill, or you just never know. But they will most likely pass an amendment to make clear that even systems that do not have the capacity to store, produce, or generate random or sequential numbers may also be deemed an ATDS, and therefore bring everyone right back under the TCPA in terms of the requirement for prior express consent. Personally, if Congress does anything at all, I think it will kind of take a pass on the hard work. And what I mean by that is similar to what Congress did when passing the Trace Act to curtail robocalling in general. I think Congress, if it does anything, will take similar action and simply direct the Federal Communications Commission to promulgate regulations that expand the definition of an automatic telephone dialing system such that the interpretation would be that if the system can simply store numbers and dial such numbers, it will be deemed an ATDS. Only time will tell what will happen with Congress, but in the meantime, I would recommend that you continue to collect consent for purposes of leaving pre-recorded messages and using an artificial voice, that you no longer need to adhere to the strict requirements for prior express consent when dialing a consumer using any type of an automated platform or system, or when texting a consumer. I will also remind you that in future conversations about this topic, we will also discuss where the TCP ends in terms of requiring consent, the Cellular, Telephone, and Internet Association and other regulations, including carrier requirements, kick in with regard to text consent. Thank you for listening to today's video podcast. If you have any questions, we always encourage you to talk to your sales representative or contact me directly at Rozanne Anderson at OntarioSystems.com. Thank you.